Pleasure and privilege to welcome you this afternoon to our College of Law and the Edward G. Donnelly Memorial Lecture. I will introduce the lecture series, and Professor Ashdown will have the honor of introducing our speaker. This lecture series honors and memorializes the life and the contributions of Edward G. Donnelly, a distinguished lawyer who was engaged in the practice of law in Morgantown, West Virginia from the date of his graduation from our College of Law in 1899 until his death in June of 1952. Not only was Mr. Donnelly an outstanding lawyer, he was actively involved in the Morgantown community, his church, civic organizations, and banking. Through this lecture series, made possible by a gift from his widow, Eleanor T. Donnelly, and his son, Robert T. Donnelly, his services to the community and to our university lives on. While the lecture series memorializes Edward G. Donnelly, it is a fitting part of his son, Robert T. Donnelly's legacy of contributions to our College of Law and to the legal profession in West Virginia. Bob Donnelly was the first individual to be awarded the Justitia Officium Award, the highest award that is given by our College of Law. He was a 1926 graduate of our law school, and like his father, a distinguished lawyer engaged in the practice of law here in Morgantown. In addition, he was an outstanding member of our faculty, was the author of the leading work on coal, oil, and gas in Virginia and West Virginia, and the author of the West Virginia annotation to the restatement of contracts. He also served as a justice on the West Virginia Supreme Court of Appeals. Because of the generosity of the Donnelly family, our College of Law has been able to bring outstanding jurists and legal scholars to our campus. Judge Donnelly would indeed be very proud that his gift to our College of Law has made it possible for a justice of the United States Supreme Court to be with us today, to spend time with our students, and to deliver the Donnelly Memorial Lecture. President Hardesty will welcome Justice Ginsburg on behalf of our university, and then Gerald Ashdown, the James H. Buck and June N. Harless Professor of Law, will introduce our speaker today. At this time, it is my pleasure to introduce the 21st President of West Virginia University, David C. Hardesty.
Justice Ginsburg, ladies and gentlemen, not only greetings from the General University, not only to you, Justice, but to all of you here today and to the students who are out in the hallway, and to others who may be listening and watching remotely. We welcome you each and every one. I think I should note the presence of several members of the judiciary, both the federal bench and the state bench in West Virginia. It's very rare that so many are assembled at one time, and that precludes us commenting, as I would like to, extensively on each. But I would like for them to stand, the members of the federal bench and state bench here in West Virginia, and be recognized, if you would, please. In recent weeks, the Supreme Court of the United States has exercised an unusually strong hold on the attention of all of us in America. We mourn the death of Chief Justice William Rehnquist, and we followed with great interest the confirmation process for the new Chief, Justice John G. Roberts, and President Bush's nomination of Harriet Miers to replace retiring Justice Sandra Day O'Connor. Changes to the court command our interest, of course, because while the work is sometimes less visible to the average American, it is nevertheless true that the court has a tremendous impact on our lives. The court interprets our Constitution. It protects the rights afforded us enshrined in the Constitution. It is the ultimate arbiter of the law of our land, and apropos of this setting, it is often a teacher of the law and the thinking processes behind the law. To hear from a person who's reached the pinnacle of American jurisprudence and whose decisions help to direct our nation's future direction is an incredible opportunity, not just for our students, but for the faculty of this college and this university and our community and others who will read indirectly our speaker's remarks. As was indicated, Justice Ginsburg will be introduced by a colleague, Jerry Ashdown, in just a few minutes. Suffice it to say that for 12 years, she has brought her keen legal mind and sense of dignity and passion for civil liberties to bear on the great concerns of our age. And she has done that for a total of 25 years on the appellate bench. Democracy, the late Justice Brandeis said, is more difficult to maintain than it is to establish. Throughout our history, the Supreme Court of the United States has played a critical role in defining and defending the rights and responsibilities and being the arbiter of the various tension among these rights and responsibilities in our society. So it's a great honor for me to welcome you, Justice. I've enjoyed our brief conversations, and I know that this is going to be a special day in the life of the College of Law of West Virginia University. Thank you for coming.
First, let me welcome all of you to the College of Law, and I would especially like to welcome Justice Ginsburg and those of you outside the law school community. We think we have a pretty special and dynamic atmosphere here, which I think is recognized by our colleagues around the country, if not yet by U.S. News and World Report, but we're working on that. Justice Ginsburg is actually the fourth Supreme Court justice we have had here at the College of Law in recent history. Chief Justice Berger was here in the 80s, followed by Chief Justice Rehnquist and Justice O'Connor in the late 90s. And so we're very proud to have Justice Ginsburg here now in 2005. This is not her first trip to West Virginia. Actually, she was here in 1978 when she was on the Columbia Law faculty and was litigating gender discrimination cases for the ACLU. Let me start by telling you that Justice Ginsburg was born and grew up in Brooklyn, New York, which should tell you a little bit in the beginning about her feistiness. She attended Cornell as an undergraduate student and then attended both Harvard University and Columbia Law Schools. In fact, I think to this day she's the only person to serve on the law reviews at both of those schools. She graduated then first in her class from Columbia Law School. And I guess I should digress and tell you a couple of little anecdotes. We talked about at least one of them this morning. When she was at Harvard, one of the deans said to her and the handful of women in the Harvard student body at the time, why are you taking seats here reserved for men, particularly when no law firms will hire you? And then when she graduated from Columbia with stellar credentials, her friends of Justice Felix Frankfurter, who was on the Supreme Court at the time and considered to be one of the premier clerkships in the country, his friends asked him to consider Justice Ginsburg as a clerk. And at that time, he refused to even interview Justice Ginsburg, and he admitted that he just wasn't ready to hire a woman. Now, Justice Ginsburg eventually wound up with a clerkship with a federal district judge from the Southern District of New York, a fellow named Edmund Palmieri. The Southern District of New York, as you may know, is a very important trial district, federal district in the United States. So that's where she clerked for 2 years. She then joined the law faculty at Rutgers University, where she taught, I believe, from 1963 to 1972, when she moved on to the prestigious Columbia Law School faculty. And before going on to the bench, she's had a rather long and stellar career litigating, while she was teaching first at Rutgers and at Columbia, litigating gender discrimination cases. In fact, her career in a lot of ways parallels that of the late Justice Thurgood Marshall. As you probably all know, Justice Marshall, prior to being on the court, was a pioneer in litigating racial discrimination cases for the NAACP. Justice Ginsburg's career parallels that in many ways because she spent a good bit of her prejudicial career litigating gender discrimination cases. In fact, as early as 1971, she wrote a report for the U.S. Civil Rights Commission on sex bias in all federal statutes. That report strongly advocated passage of the proposed Equal Rights Amendment at the time, of which Justice Ginsburg was always an aggressive advocate. She was the ACLU's, American Civil Liberties Union General Counsel from, I believe, 1973 to 80, and on the National Board of Directors from 1974 to 1980. In fact, that's when she was with us in the late 70s. She argued 6 cases before the United States Supreme Court. Out of those 6, she won 5. And another little anecdote we were talking about this morning, during one of those arguments, the late Chief Justice Rehnquist, justice at the time, asked her, can't you be satisfied with Susan B. Anthony's face on the silver dollar? And I asked her this morning, I said, well, he was joking, wasn't he? And she said, well, of course he was joking, but the fact that that was even said told you something about the 1970s and the thinking at the time, and I think that's accurate. Justice Ginsburg spent, like I say, a lot of her career dealing with laws that discriminated between men and women. She would challenge laws that even benefited women. And one of her more memorable statements, she one time said that it's not women's liberation, it's women and men's liberation. Her judicial career began in 1980 when President Carter appointed her to the United States Court of Appeals for the D.C. Circuit, where she remained and served until 1993 when President Bill Clinton nominated her to serve on the United States Supreme Court in the seat vacated by Justice White. She was confirmed by the Senate in August of 1993 by a vote of 97-3. And I'm going to editorialize here for a minute because this is something I've not read about Justice Ginsburg and don't really know to be true for a fact, although we talked a little bit about it this morning. As a constitutional law teacher, it seems to me that one of her most fulfilling moments in her career till now must have come when she wrote the majority opinion in United States versus Virginia. United States versus Virginia is the case that declared the Virginia Military Institute, VMI, all-male admissions policy unconstitutional. In that case, she wrote that in order for a state to discriminate against men and women, they had to offer and prove a, quote, exceedingly persuasive justification. As we constitutional law scholars and teachers and students know, that's one that's very difficult to meet. VMI couldn't meet it after 150 years, century and a half of tradition and history. She mentioned to me this morning one thing that I of course I wouldn't know. She said that one of her most gratifying letters she received after the VMI case from a former VMI graduate who said that he graduated in 1965 from VMI, and in the years since he'd met a lot of women that were tougher than he was, and that he wanted his daughter and her mother as well would have wanted her to go to VMI. So that's the letter she received after that case was decided in Justice Ginsburg's majority opinion. I want to offer one more thing. This is something I discovered in doing the research for the introduction today. I understand that Justice Ginsburg has kind of a nascent acting career, and she's actually appeared at the Folger Shakespeare Theater in Washington in a number of parts, minor parts, and it stealthily. And in one of the parts, she was able to, she read the lines from Henry VI, where the butcher says, first we kill all the lawyers. But then she added, and next the reporters. So please join me in welcoming Justice Ruth Bader Ginsburg to the College of Law.
Thank you. Please be seated. That was an introduction to treasure. And I'm very pleased to follow my two colleagues, first Justice Sandra Day O'Connor, and then my chief, Chief Justice William H. Rehnquist, in delivering an Edward G. Donnelly Memorial Lecture here. Before I begin my talk, it is fitting, I hope you agree, to remember the chief under whom I served from 1993 until September 2005. On September 4th, the day after Chief Justice Rehnquist died, each of us gave the court's Public Information Office a statement about the chief to release to the press. Mine read, Chief Justice William H. Rehnquist was the fairest, most efficient boss I have ever had. Speaking of his role in a 2002 address, he said, the Chief Justice has placed in his hands some of the tools that will enable him to be primus among the pares, but his stature will depend on how he uses them. In his leadership of the U.S. judiciary and his superintendence of the Supreme Court, William H. Rehnquist used to great effect the tools Congress and tradition entrusted in him. A plain speaker without airs or affectations, the chief fostered a spirit of collegiality among the 9 of us, perhaps unparalleled in the court's history. He regarded an independent judiciary as our country's hallmark and pride, and in his annual reports, he constantly urged Congress to safeguard that independence. On the obligation key to judging, he cautioned that a judge steps out of the proper judicial role most conspicuously and dangerously when the judge flinches from a decision that is legally right because the bottom line is not the one the home crowd wants. I held him in highest regard and affection and will miss him greatly. As you've been told, I last visited the University of West Virginia College of Law in 1978, before the birth of many of the students I've been speaking with. As a participant in the university's Festival of Women, I described the advances society had made in the 1970s toward equal citizenship stature for women and the considerable distance remaining between then current conditions and achievement of that goal. For example, 2 states, Missouri and Tennessee, still made jury service obligatory only for men. And at the beginning of Jimmy Carter's presidency in January 1977, only one woman, Ninth Circuit Judge Shirley Mount Hofstetler, sat on a federal appellate bench, and only 5 of nearly 400 federal district court judges were women. My remarks concern women's remarkable progress in recent decades, both at the bar and on the bench in the United States generally, and in West Virginia as well. In my growing up years, men of the bench and bar generally held what the French called an idée fixe, the unyielding conviction that women in lawyering, no less judging, do not mix. It ain't necessarily so, most ancient texts reveal. In Greek mythology, Pallas Athena was celebrated as the goddess of reason and justice. To end the cycle of violence that began with Agamemnon's sacrifice of his daughter, Iphigenia, Athena created a court of justice to try Orestes, thereby installing the rule of law instead of the reign of vengeance. An even earlier example is the biblical Deborah from the book of Judges. She was at the same time prophet, judge, and military leader. This triple-headed authority was exercised by only two other Israelites, both men, Moses and Samuel. People came from far and wide to seek Deborah's judgments. According to the rabbis, Deborah was independently wealthy, thus she, unlike many recent law school graduates, could afford to work entirely pro bono. The U.S. legal establishment, even if its members knew of Athena and Deborah, for too long resisted admitting women into its ranks. It was only in 1869 that Iowa's Arabella Mansfield became the first female to gain admission to the practice of law in this country. That same year, the St. Louis Law School became the first in the nation to open its doors to women. Lemma Barkaloo, among the first women to attend St. Louis, earlier had been turned away by my own alma mater, Columbia. In 1890, when Columbia denied admission to 3 more female applicants, a member of the university's board of trustees is reported to have said, "No woman shall degrade herself by practicing law in New York, especially if I can save her." The clack of these possible Porsches will never be heard in our university's moot court. That board member surely lacked Deborah's prophetic powers. Once granted admission to law schools, women were not greeted by their teachers and their classmates with open arms and undiluted zeal. An example from the University of Pennsylvania Law School. In 1911, the student body held a vote on a widely supported resolution to compel members of the freshman class to grow mustaches. A 25-cent per week penalty was to be imposed on each student who failed to show substantial progress in his growth. Thanks to the 11th hour plea of a student who remembered the lone woman in the class, the resolution was defeated, but only after a heated debate. The bar's reluctance to admit women into the club played out in a series of inglorious cases. In denying Myra Bradwell admission to the bar, the Illinois Supreme Court observed in 1869 that as a married woman, Bradwell would not be bound by contracts she made. The Illinois court thought it instructive, too, that female attorneys were unknown in the mother country. Concerning English practice, Myra Bradwell wrote, "According to our English brothers, it would be cruel to allow a woman to embark upon the rough and troubled seas of actual legal practice, but not beyond the pale to allow her to govern all England with Canada and other dependencies thrown in. Our brothers will get used to it, and then it will not seem any worse to them to have a woman practicing in the courts than it does now to have a queen rule over them." In 1875, when Lavinia Goodell of Wisconsin was denied admission to her state's bar, a justice of the Wisconsin Supreme Court remarked, "It would be revolting to all female sense of innocence that women should be permitted to mix professionally in all the nastiness of the world which finds itself into the courts of justice." An enlightened local newspaper commented in an editorial, "If her purity is in danger, would it not be better to reconstruct the court and the bar than to exclude women?" Goodell persisted, and Wisconsin's legislature trumped the state's high court, and in 1879, she became a member of the state bar. In 1896, with the admission of Agnes Westbrook Morrison, West Virginia became the 31st state to admit women to the practice of law. But as late as 1968, the law remained largely a male preserve, as textbooks and teachers confirmed. For example, a widely used first-year property case book published that year made this parenthetical comment: "For after all, land, like woman, was meant to be possessed." The few women who braved law school in the 1950s and 1960s, it was generally supposed, presented no real challenge to or competition for the men. One distinguished law professor commented at a 1971 Association of American Law Schools meeting, when colleagues expressed misgivings about the rising enrollment of women that coincided with the call-up of men for Vietnam War service. "Not to worry," he said. "What were women law students after all? Only soft men." The critical mass achieved in the 1970s contrasts with the impermanent jump in women's enrollment in law schools during World War II. In that earlier era, the president of Harvard was reported to have been asked how the law school was faring during the war. "It's not as bad as we thought," he replied. "We still have 75 students, and we haven't had to admit any women." Compare the concern said to have been expressed by the same university's head in Vietnam War days. "We shall be left with the blind, the lame, and the women." Why did law schools wait so long before putting out the welcome mat for women? Well, arguments ranged from anticipation that women would not put law degrees to the same full use as men, to the potty problem, the absence of adequate bathroom facilities for women. Despite the chill air, the depressing signs conveyed no women wanted here. Female lawyers would not be put down. In the early 1960s, women accounted for only 3% of the nation's lawyers. Today, their ranks have increased tenfold. In the law schools from 1947 till 1967, women filled less than 5% of the seats each academic year. Today, women account for more than 50% of entering law students nationwide. And the class of 2007 at the West Virginia University College of Law, I'm told, is evenly divided between men and women. Progress is evident behind the podium, too. In 1919, Barbara Armstrong was appointed to the Berkeley, the Boat Hall Law Faculty. She became an assistant professor of law and economics in 1923, the first woman ever to gain a tenure-track post at an ABA law school. More than 2 decades later, in 1945, only 2 women had made their way to tenure-track positions at U.S. ALS law schools. When I was appointed to the Rutgers faculty in 1963, women headed for tenured positions at AALS member law schools still numbered under a score. But by 1990, more than 20% of law professors were women, and today, women are 23% of the full professors with tenure and more than 35% of law faculty members overall. At this school, I'm told, women hold 1/3 of the tenure track faculty appointments and compose 1/3 of the school's adjunct faculty. In 1994, the College of Law appointed a woman as dean, its first, Terry Foster. And today, Dean Fisher is aided by, I think, 4 women helping him as assistant deans. Strides in the law are similarly marked in all but 2 states, Alabama and Louisiana. A woman has served as president of the State Bar Association, and one of the 2 holdouts, Louisiana, recently elected a woman to serve as president commencing in June 2006. To date, over 130 women have headed state bar associations, including 9 who currently hold that position, and 2 women have served as presidents of the American Bar Association in the decade just past. A 3rd will become president of the ABA next year. Women began to show up on the bench in numbers in the 20th century's middle years. Florence Ellenwood Allen was appointed to the U.S. Court of Appeals for the Sixth Circuit in 1934, Bernita Shelton Matthews to the U.S. District Court for the District of Columbia in 1949, Shirley Mount Hustetler to the U.S. Court of Appeals for the Ninth Circuit in 1968. This afternoon, I will speak briefly of only one of those 3 way pavers, Florence Allen, the first woman ever to serve on an Article III federal court. I will also mention a way paving jurist from West Virginia, Elizabeth Hallinan. Before joining the federal bench, Florence Allen achieved many firsts in Ohio. First female assistant prosecutor in the country, first woman elected to sit on a court of general jurisdiction, and the nation's first female state Supreme Court judge. Long tenured on the Sixth Circuit, Allen eventually served as that circuit's chief judge, another first. It was rumored that Allen might become the first female member of the U.S. Supreme Court. In 1949, 2 vacancies opened on the court. President Truman reportedly was not opposed to the idea of filling one of them with a woman. But as political strategist India Edwards, then head of the Women's Division of the Democratic National Committee, recalled, Truman ultimately decided that the time was not ripe. Edwards wrote of the Brethren's reaction when Truman sought their advice. A woman as a justice would make it difficult for the other justices to meet informally with robes and perhaps shoes off, shirt collars unbuttoned, discussing their problems and coming to decisions. I am certain, India Edwards said, that the old line about there being no sanitary arrangements for a female justice was also included in the reasons for not wanting a woman. Times have indeed changed. To mark my 1993 appointment to the Supreme Court, my colleagues ordered the installation of a women's bathroom in the justice's robing room, equal in size to the men's. Turning to West Virginia's frontrunner, Elizabeth Hallinan, a graduate of this College of Law in 1951, the lone woman in a class of 136. She served on the State Board of Education from 1955 to 1957, in the House of Delegates of the state legislature from 1957 to 1958. She served the next year as Assistant Commissioner of Public Institutions, overseeing the state's prisons, mental hospitals, and juvenile homes. In 1959, she became the first woman seated on a West Virginia court of record, serving on the Kanawha County Juvenile Court from that year until 1969, when she became the first female to head West Virginia's Public Service Commission. Appointed to the U.S. District Court for the Southern District of West Virginia in 1983, Judge Hallinan became the first West Virginian woman to ascend to the federal bench. One of her first headline-making federal cases involved a West Virginia law calling for a designated period that could be devoted to silent prayer in public schools, correctly projecting the outcome of Wallace against Jaffrey, a case then pending in the U.S. Supreme Court. Judge Hallinan declared the law unconstitutional, calling it a hoax conceived in political expediency. She received more than 1,000 letters protesting her decision. Judge Hallinan anticipated an adverse reaction to the decision, but she observed that fidelity to the Constitution, as construed by the Supreme Court, is a duty which cannot, in good conscience, be shirked because of intimidation. As the late Chief William H. Rehnquist might have observed, she did not flinch from a decision that was legally correct, even though the bottom line was not the one the home crowd wanted. Judge Hallinan later said that she had been moved by the testimony of a young Jewish girl who described the ostracism she experienced when she refused to join her classmates in prayer. Brave wage payers like Judge Allen and Judge Hallinan helped to advance the end of the days when women appeared on the bench only as one-at-a-time curiosities. At the federal level, the administrations of Kennedy, Johnson, Nixon, and Ford combined had appointed just 6 women to Article III courts. President Carter appointed a barrier-breaking number, 40, to life-tenured federal judgeships. President Carter literally changed the complexion of the U.S. judiciary by drawing on the talent of all of our nation's people, including women and members of minority groups. After he broke away from the historic pattern and appointed women to the bench in numbers, there was no return to old ways by any succeeding president. President Reagan made headlines in history when he appointed the first woman to the Supreme Court, my dear colleague, Justice Sandra Day O'Connor. He also appointed 28 women to other federal courts. The first President Bush, in his single term in office, appointed 36 women to the federal bench. President Clinton, over an 8-year span, appointed a grand total of 104 women, and our current president to date has appointed 45 women to the federal judiciary. Today, every federal court of appeals, except the First, Eighth, and the Federal Circuit, has at least 3 active women judges. The Fourth Circuit, of which West Virginia is part, has 3. 8 women have served as chief judge of a U.S. Court of Appeals, including 3 who currently occupy that post. 46 women have served as chief judge of a U.S. district court, including the 25 now holding that position. Among the 25 is Irene M. Keeley, who presides over the Northern District of West Virginia, a 1980 graduate of the College of Law. Now Chief Judge Keeley devoted 12 years to private practice in Clarksburg and served on the adjunct faculty of this law school. President George H.W. Bush nominated her to the district court bench in 1992. She became chief judge in 2001. To date, nearly 250 women have served as life-tenured federal judges, 58 of them on appellate courts. Currently, 44 women are serving as active members of U.S. Courts of Appeals and 155 as active judges in U.S. district courts. Yes, there are gains yet to be made, considering, for example, that women make up less than 1/4 of the federal judiciary. But what a large distance we have come since my 1959 graduation from law school, when Florence Allen remained the sole woman ever to have served on the federal appellate bench. In the state courts, progress is equally noteworthy. Every state except Oregon and Indiana has at least one woman on its court of last resort. Almost 1/3 of the chief justices of those courts are women. Margaret Workman, a 1974 graduate of this College of Law, holds the distinction of being the first woman elected to the Supreme Court of Appeals of West Virginia, thus becoming the first woman ever elected to statewide office in West Virginia. Another graduate of this law school, Justice Robin Jean Davis, class of 1982, is currently the most senior justice on the Supreme Court of Appeals and twice served as its chief. But looking beyond our borders, we are not in the lead. The Chief Justice of the Supreme Court of Canada is a woman, as are 3 of that court's 8 other justices. The Chief Justice of New Zealand is a woman. 5 of the 16 judges on Germany's Federal Constitutional Court are women, and a woman served as president of that court from 1994 until 2002. Women account for 6 of the 18 judges serving on the International Criminal Court and 4 of the 10 recent nominees to that court. True, as Gene Coyne of Minnesota's Supreme Court famously said, at the end of the day, a wise old man and a wise old woman will reach the same decision. But it is also true that women, like people of different racial groups and ethnic origins, contribute to what a fine jurist, the late federal Fifth Circuit judge, Alvin Rubin, described as a distinctive medley of views influenced by differences in biology, culture, and life experience. Our system of justice is surely richer for the diversity of background and experience of its judges. It was poorer in relation to the society law exists to serve when nearly all of its participants were cut from the same mold. I opened these remarks with a remembrance of Chief Justice Rehnquist. I would like to conclude them by expressing my appreciation and admiration for Justice Sandra Day O'Connor. Her bright mind and vibrant spirit have added immeasurably to the jurisprudence and collegiality of the U.S. Supreme Court for 4 years. Justice O'Connor has been rightly praised for her independence, self-reliance, practicality, and self-possession. Of all the accolades, one strikes me as describing my dear colleague best. Growing up on the Lazy Bee Ranch in Arizona, Justice O'Connor could brand cattle, drive a tractor, fire a rifle with accuracy well before she reached her teens. One of the hands on the ranch recalled his clear memory of Sandra Day. She wasn't the rough and rugged type, but she worked well with us in the canyons. She held her own. Justice O'Connor did just that at every stage of her professional and family life. The first woman to serve on the Supreme Court brought to the conference table experience others did not possess. The experience of growing up female in the 1930s, 40s, and 50s, of raising a family, of doing all manner of legal work, government service, private practice, successful candidacies for legislative and judicial office, leadership of her state senate, state court judicial service, first on a trial court and then on an intermediate appellate bench. Hard worker and quick learner that she is, she mastered the mysteries of federal law and practice and held her own from the very start. Justice O'Connor's welcome when I became the junior justice is characteristic. She knew what it was like to learn the ropes on one's own. She told me what I needed to know when I came on board for the court's 1993 term, not in an intimidating dose, just enough to enable me to navigate safely my first days and weeks. At the end of the October 1993 sitting, I eagerly waited my first opinion assignment, expecting, as the legend goes, that the brand new justice would be slated for an uncontroversial, unanimous opinion. When the list came round, I was dismayed. The chief had given me an intricate, not at all easy ERISA case on which the court had divided 6-3. ERISA is the acronym for the Employee Retirement Income Security Act of 1974. It may be the most dense piece of legislation passed in the last century. I sought Justice O'Connor's advice. It was simple. Just do it, she said. And if you can, circulate your draft before he makes the next set of assignments. Otherwise, you will risk receiving another tedious case. That advice, just do it, typifies Justice O'Connor's approach to all things. Waste no time on regret or resentment. Get the job done. Justice O'Connor was a dissenter in the case that was my first. As I read the bench announcement summarizing the court's decision, she gave a marshal's office attendant a note for me. It read, "This is your first opinion for the court. It is a fine one. I look forward to many more." As first woman on the Supreme Court, Justice O'Connor set a pace I could scarcely follow. To this day, my mail is filled with requests that run, as my invitation to this College of Law did, this way. Last year, or some years before, Justice O'Connor visited our campus or country, spoke at our bar or civic association, did this or that. Next, words politely phrased, but to this effect: "Now it's your turn." My secretaries once imagined that Justice O'Connor had a secret twin sister to share all her appearances. The reality is she has an extraordinary ability to manage her time. Why does she go to Des Moines, Lithuania, or Rwanda when she might rather fly, fish, ski, play tennis, or golf? In her own words, for both men and women, the first step in getting power is to become visible to others, and then to put on an impressive show. As women achieve power, the barriers will fall. As society sees what women can do, as women see what women can do, there will be more women out there doing things, and we'll all be better off for it. There was a time in 1988 when Justice O'Connor's energy flagged, long months in which she endured rigorous treatment for breast cancer. Though tired and in physical discomfort, she did not miss a sitting day on the court that busy term. Once fully recovered, she spoke of that hard time. Her account, carried on public TV, gave legions of women hope, the courage to continue to do as she did. She went back to the 8 a.m. exercise class that she had inaugurated at the court long before it was predicted she could. There was a lot I couldn't do, she said, but I did a little. I did what I could. What she could became evident years later, the day the Olympic women's basketball team visited the court. Justice O'Connor led the team on a tour that ended at the highest court in the land, that is the full basketball court on the building's top floor. The team practiced some minutes, then passed the ball to Justice O'Connor. She missed the first shot, but the second went straight through the hoop. Each case on the court's docket attracts Justice O'Connor's best effort, and she is never shy about stating her views at court conferences or in follow-on discussions. When she writes separately, concurring or in dissent, almost invariably, she presents her disagreement plainly and professionally. She wastes no words castigating colleagues' opinions as Orwellian, profoundly misguided, or a jurisprudential disaster, and I am making none of those up. In the 12 years and more we have served together, court watchers have seen that women speak in different voices, just as men do. Even so, advocates, each term until the current one, revealed that they had not fully adjusted to the presence of two women on the high court bench. During oral argument, distinguished counsel, including a Harvard Law School professor and more than one Solicitor General, began their responses to my questions. Well, Justice O'Connor. Sometimes when that happened, Justice O'Connor would smile and crisply remind counsel, she's Justice Ginsburg, I'm Justice O'Connor. Later this term, sadly for me, there will be no need for the T-shirts presented to us in 1993 by the National Association of Women Judges. Hers reads, I'm Sandra, not Ruth. Mine, I'm Ruth, not Sandra. In June 1996, when I read the summary of the court's opinion in the United States against Virginia, the Virginia Military Institute case, I looked across the bench to Justice O'Connor as I referred to her path-marking opinion in Mississippi University for Women v. Hogan, which held that qualified men could not be refused admission to a state-operated school for nursing. That decision issued in 1982, at the end of Justice O'Connor's first term on the court. The judgment, striking down a classically stereotypical gender line, was a close 5-4. The judgment 14 years later, in the VMI case, was 7-1. What occurred in the intervening years at the court and elsewhere in society? Justice O'Connor said it best when she appeared one night as Isabel, Queen of France, in the Shakespeare Theater's production of Henry V. Happily, a woman's voice may do some good. Justice O'Connor's voice has done enormous good in our nation and world. She has endeavored tirelessly to improve the administration of justice, promote professionalism of the bar, and encourage the integrity and independence of the judiciary. She has earned the respect of jurists everywhere for her influential legal reasoning, her meticulous preparation for court sessions, and her open-mindedness, which defies any ideological label. In her work and days at the court, she strives to make what was momentous for women in 1981 no longer extraordinary, but entirely expectable. In that effort, I will strive to follow the path she marked. Thank you. Be seated, please.
Justice Ginsburg has indicated a willingness to entertain some questions. So.
Thank you very much for your remarks. As a scientist and as a Catholic, I am becoming more and more disturbed by the legal replay of the Scopes trial in our society. And I'm worried about the struggle between science and religion that I see as a false opposition. I'm wondering when the new nominee, religion is given as her predominant, by some people, as her predominant ability to become a justice. That bothers me. Do you see that same struggle coming back to our society in religion versus science?
That the struggle is there in some religious quarters, yes, but in others, not. We have had an unusual number of Catholics on our court, all good Catholics, but they do not think alike on some important questions. Think of Justice Brennan and think of Justice Scalia. So I suspect the U.S. public will be the real decision makers on this question, and I trust in their good judgment overall. I mean, we have been a model for the world in having a no establishment clause, a separation of church and state, which I think has been a healthy thing for both churches and states. I mean, just compare countries that do have an official state church. In Scandinavia, for example, the ministers were public servants, they were civil servants, and people were in church for christenings, for marriages, and for funerals. Now that they have separated the church from the state so that the churches must be self-supporting, the attendance has gone up. So I think that the United States has shown that it's healthy, both for religious institutions and for the state, to maintain their distance. There's a question there.
Thank you. Do you believe the Kelo decision concerning eminent domain diminished the private property rights of individual property owners? And as a follow-up, do you believe it's appropriate for state legislatures to adopt protections for property owners?
To your second question, absolutely. And I explained in the morning session I had with students the tremendous misunderstanding about what the Kelo case held. It held only one thing, that the unelected Supreme Court was not the proper decision maker of that question. It was, in the first instance, the City Council, the second instance, the state legislature, that this was a decision to be made by the people through their elected representatives and not by the Supreme Court under some grandly general constitutional clause, the Due Process Clause. Justice Stevens, who wrote the opinion in the Kelo case, gave a talk in which he gave 6 examples of cases from the last term of court where, if he had been in the legislature, he would have come out the other way. The Kelo case was the top of his list. He had no doubt that if he had been in the legislature, he would have blocked that project. He thinks it's great that the legislature has done so. That's exactly what should have happened. And if our decision galvanized that kind of responsibility on the part of the people's elected representatives, all the better for it. Another question?
On Wade versus Wade, are they going to keep it, or do you think that they are going to get rid of it?
Well, that's a question obviously I cannot answer because maybe it will come to us. All I can say is, and the law students here probably know, that some terms ago, before I was appointed to the court said Roe v. Wade is precedent, it has been decided, and it will continue to be the precedent of the court. We are not going to change that interpretation of the Constitution after a generation of women have grown up with that being the precedent in place.
I recently read a survey statistic that indicated, and I can't remember the number now, but a surprisingly large percentage of the American public thinks our courts have run amok, which is, a lawyer, is astounding to me because I hadn't noticed anything like that happening. There's times I've wanted it to, but it gave me great concern because as an attorney, I perceive our judiciary and its integrity to be such an important role, part of the democracy in which we live and the protection of our rights. Have you seen anything like that? Do you think the judiciary is under more attack? And if so, where do you think that's coming from? And what do you think needs to be done?
I think we need more lawyers like you because we can't defend ourselves. We do need lawyers and law teachers to explain what is the job of a judge, which seems to be badly misunderstood by many members of our Congress. I mean, for example, the pending resolutions and bills that say it's un-American to refer in a decision of a U.S. court to any decision of a foreign tribunal. Indeed, it could be an impeachable offense. That's the lack of understanding behind those resolutions, the lack of appreciation that we never look abroad for precedent, that this is not authority that binds us, but there are brilliant legal minds on benches all over the world. So, to give the example I gave to the students this morning, on the Supreme Court of Israel, there is a very articulate Chief Justice, Aharon Barak. He commented, the United States had its 9/11. We in Israel have had our 9/12, our 9/13, and so on. We have encountered continually the problem of how to maintain liberty in a time of terror. And that court has a book of its judgments dealing with the difficult question of preserving liberty despite the desperate need for security. Wouldn't it be as enlightening for our judges to look at those judgments as it might be to read an article by a law professor? I hope that understanding can spread among the public and especially our legislators. So I recognize that there's a certain jealousy as far as the federal judiciary is concerned. After all, we're appointed for life. No one can reduce our salaries. And they have to run periodically for election. But I don't remember a time when there has been such tension between the judiciary and the legislature. And I just hope that it goes back to the way it was. It's recent. At the time of my nomination in 1993, President Clinton, before he announced his nomination, called Senator Orrin Hatch. This is in Orrin Hatch's memoir, so it's public information, and said, who would be acceptable to you for this vacancy? And Orrin Hatch gave him two names, Stephen Breyer and Ruth Ginsburg. That kind of rapport seems to be missing at the current time, but I hope the pendulum will swing back. I mean, some wise person said that the symbol of the United States really isn't the bald eagle, it's the pendulum. But I do think that the more that the bar speaks out about the importance of judicial independence, the better off we will be.
Justice Ginsburg, we appreciate so much your coming to West Virginia and sharing your thoughts with us. But I was wondering whether, knowing your background as a litigator, whether on a personal level you ever miss being a litigator and being on the bench instead.
Well, there are some similarities in the role of, I mean, it is the art of persuasion. Now, I have a select group to persuade, but it's always a challenge if I'm in the minority to write an opinion that maybe will capture one or two more votes and turn. Well, the persuasion goes on all the time. It's first, as I told the students, sometimes the questions that we ask from the bench are not designed to elicit counsel's response as much as to influence one of our colleagues' thinking on an issue. And the job of trying to persuade each other, we do that at conference. So the skills are very much alike. The difference is that many times as a judge, I have to come out with a result that I don't like at all, because that's what the law requires. You mentioned the Kelo case is one. Last year, the California medical marijuana case, where there were two women who literally couldn't live without their the relief that the marijuana gave them. And yet Congress had passed a law saying marijuana is a Schedule I substance. That means it cannot be sold within the United States for any purpose. Can it be grown, sold? It's forbidden across the board. Did Congress have the authority to pass that law? I agreed with my colleagues that it did, even though we didn't like the result at all. So it's that enormous difference. In court, you represent a client. For me, I had the good fortune only to represent clients that I agreed with. But as a judge, you must sometimes come out the way you would not if you were making the laws, if you were sitting in the legislature.
Justice Ginsburg, I just wanted to let you know what most of us already know, and that's that the woman who just asked the formal question is Deborah Scudero, president of the West Virginia State Bar.
Oh, wonderful. I remember back to the days when the New York City Bar Association didn't admit women for the usual excuse they had no bathroom for the...
Justice Ginsburg, I wonder if you could comment on the trial of Saddam Hussein. Is that a trial that in any fashion can or will resemble a court of law as we know it?
Who can say? It's just beginning. I expect the pattern for it will not be our common law way. It will be the civil law, because to the extent that Iraq had a legal system, it was French civil law based, not Anglo-American common law. So that would make for very significant differences in how the trial will be run. For one thing, the lawyers will not ask the questions, the judges will. For another, they certainly won't have a jury. So the style of that trial will resemble a continental procedure, not a U.S. common law proceeding.
Justice Ginsburg, I brought my daughter and granddaughters here to hear you today, and I noticed there are many other young girls here, and you have influenced so many of us women in our legal careers. I was wondering if you could give these young girls advice as they carve their careers over the next 50 or 60 years as the world changes.
Well, just believe that you can do anything that God has given you the talent to do, and that you won't be held back because you are a girl or a boy or one religion or another or one skin color or another. My favorite story about the change in times in that regard is my own granddaughter, the oldest of my granddaughters, who's now 15, but this was when she was about 8. I was being filmed, and she was with me that weekend for some documentary. And she said that she would like to be in the movie. So I said, okay, Clara, what would you like to be when you grow up? And this child answered, I would like to be president of the United States of the world. Now that girls are growing up believing that they can do that is something wonderful.